Pam. Okay, it is 10 o'clock. I will go ahead and call the meeting to order. Representatives of all three districts are present. Notice that the meeting was properly posted on March the 9th, 2026. Agenda item number 1 is approval of minutes.
Motion approved. Second.
Okay, I have a motion and a second. All those in favor?
Aye.
Aye. Thank you. And without objection to the committee, I know we have some people present to speak on certain agenda items. And so without objection, I would like to jump down to agenda item number 13. Discussion and possible action regarding a renewal of an agreement between the BOCC and the Oklahoma County District Attorney's Office. See, we have DA Behenna and Miss Lisa.
I'm going to let Lisa go through a PowerPoint very quickly and put together on the contract that we provided last year. I think it really breaks down into what are statutory required responsibilities and what additional responsibilities does the DA's office provide.
Okay, perfect. Right. Sharon, did we have this attached to the agenda?
It was not attached.
Okay.
Later, so you'll have to see that.
Perfect. If I could have a motion to receive the presentation.
Move to receive. Second.
All those in favor say aye.
Aye.
Thank you.
And like I said, you should all have a copy of this as well in front of you. This is just kind of a 2025 year in review to let you know where your money went last year and what services were provided by legal. Okay, so just to let you know, in 2025, the average attorney billable hour in Oklahoma was $278 per billable hour for lawyers. For non-lawyers, it was $172. The reason why this information is important, that's taken from a national study that was done. That's the website where you can go check that out. The reason why that is important is because that shows you what the average attorney fee in Oklahoma would be for billable hours for any attorney that you were to hire. And, you know, we are worth it.
Now, question, does this include hours that counsel use to defend the Oklahoma County Jail?
The Oklahoma County, are you talking about the Oklahoma County Jail from last year?
Yes.
This is these hours are broken down, and you'll see this. 852 requests for legal services were provided to our office from Oklahoma County. This presentation is talking about the services that were provided to Oklahoma County and the BOCC. And yes, some of that litigation is included, but not all of the litigation. We're only looking at the cases where BOCC is a party in with regard to these numbers.
Okay. Thank you.
If I can just say this, that we did have a separate, the DA's office did have a separate contract with the jail trust, and that was canceled as of January of this year. So that contract is not being paid by the county to the jail trust for them to pay us.
Okay.
This is just representation of the county electeds.
Right. I think the we had to give a 30-day notice of cancellation, and I think the actual cancellation date for that contract was in February, but we gave notice in January for the cancellation. So that cancellation was effective, I believe, February 10th. So, but this is a year in review of 2025, and I have kept the numbers specifically to the services that were provided to Oklahoma County, BOCC, and all of its offices. So this is how it breaks down. In 2025, we received 852 requests for legal services. That was the written requests for legal services. That doesn't include all of the verbal telephone calls to Vicki or myself or any of the other attorneys that would take phone calls or come to meetings and provide legal counsel and advice verbally. This is just the 852. Now, this is a breakdown of where the 852 requests for legal services were coming from. Now, the treasurer and the court clerk are high because the treasurer's office, the DA's office provides legal representation in every foreclosure proceeding in which the county is owed money for ad valorem taxes. Also, we help the treasurer's office out with return of excess proceeds when there is a dispute on who the true owner is. The DA's office helps the treasurer with regard to that, which is not litigation, by the way, but it is a service, an extra service that we provide to the treasurer's office. So as you note, the treasurer's office and the court clerk's office, now the court clerk's office sends us every single tort claim, every single notification of lawsuit. Now, I will tell you, Caitlin did some research recently. In our tort claim notices, a lot of people send notices of lawsuits over to Oklahoma County, and they mean Oklahoma City, or they mean a different county. And so we still have to review those to determine if we have an interest or not to protect. So we are reviewing every single notification that comes into the court clerk's office to determine whether or not that is a lawsuit or a claim against the county that we will have to defend. And that does take time and effort, and we log everything, and we keep records of everything in the event that there's a question about what was done. So benefits and retirement had 25. Some of these, county manager had 33. Each district, as you said, you all are pretty consistent. That's 39, 34, and 31. Breakdowns on request of legal services, like I said, in writing. So engineering had 16, facilities management had 35. This just kind of breaks it down. The graph on the other side of that just kind of shows you the percentages as it breaks out of which divisions or departments require the DA's services the most. Now, here are the types of legal services. Notice of tort claims. We do the tort claims investigations for the county. We basically get those tort claims in. We send out notifications to the districts asking for information about that incident. We send out a questionnaire. We also do document preservation and make people aware of the fact that they have a duty to preserve documents. That is a service that we offer that is in addition to what is required by statute. That is not something that we are required by statute to do, but we do that because we have this contract. Requests for contract review, requests for policy review, requests for legal opinion, drafting of agenda items, resolutions, contracts, etc. Litigation representation, which is the big one, and that's in all lawsuits filed against the county, regardless of where they come from. It also includes whether or not we are the plaintiff or the plaintiff's counsel, which we have been. This last year, we filed a condemnation, an encroachment case. We've represented the county in condemnation litigation, and we also, it resolved very early in 2025, but as you recall, the OKC permit litigation that we initiated, that was also part, in the beginning of 2025, we had some of those services. So that also includes representing the county when the county needs to sue one, we do that as well. Requests for HR and risk analysis, we do that. It's not required by our contract, but we do it, or not required by statute, but we do it because of the contract. Administrative hearing representation with the EOC or unemployment claims. Once again, we are not required to do that by statute, but we do it because of the contract. Requests for DA legal opinions and attending these meetings. This is how the breakdown is. If you were to take the billable hours in Oklahoma for the average attorney, and this is the old slide show with the old numbers. I apologize. This is not the correct one. The number is, it should be 821. It should be 821. The contract for the DA was right at $699,000, $420,000. So this one was based upon an older contract, and I apologize for that. But in the one in front of you is the correct number. The DA's contract was was right under $700,000. That breaks down, if you take 851 requests for legal services, that breaks down to you paying $821 for legal services per request for services. Now, as you understand, some of those requests for services might be a contract review that takes an hour, or it might be litigation review or a request for legal opinion that might take 20, 30, 40 hours plus. So on average, the contract that you are paying for, that breaks down to 3 hours per a request for agenda item. 3 hours. That's it. That's what you're paying for. So when we talk about these numbers, I want you to remember that if you were to go pay billable hours, in the other column, hours that are not represented by the 852, we have $17,514 in billable hours to receive and perform 2 to 3 hours of time to investigate tort claims. That is not required by statute, but that is on average how much we do, and that's what we spent in 2025. That was not part of the 852. $63,384 in billable hours for 228 county meetings attended by members of our office. That's with an average meeting hour attendance of 1 hour. Some meetings, as you know, take more than that. $867,360 was for 2 attorneys spending 30 hours per week dedicated to Section 1983 claims, and these are just the BOCC claims because we broke it down and not even doing a full 40 hours a week. We're saying if the dedicated time that they spent doing depositions, discovery, and doing all of the litigation requests that is required, that is breaking it down into that. So I can stand up to you here today and tell you that $964,000 in legal services were provided to the county for $700,000. And that is an estimate. That is a conservative estimate because, once again, it doesn't include some of the work and performance, and we are estimating it based on those numbers before about how long that that each type of task takes. Now, when I was at the Department of Transportation, I did risk analysis, and I was able to do contracts for outside counsel based upon the average amount of time it takes per litigation costs. And I can tell you from looking at plaintiff's counsel, when we hire plaintiff's counsel or plaintiff's counsel in these litigation cases, they're averaging about $200,000 to $300,000 in attorney's fees to get a Section 1983 case from filing to jury trial. Okay, so if you were to mirror that, if you were to go out and pay outside counsel for that, on 6 cases, we have 6 cases in 2026 that are active, BOCC only, not only, but BOCC is in those cases with the jail. In those 6 cases, if you were to take that and say, how much would it cost if we didn't have the DA representing and we had to go hire an outside firm, it would probably run you about $1.2 million on 6 cases. We're doing all of the litigation and all of the other stuff for $700,000. So these are additional services. We kind of talked about it. The DA dedicates 4 attorneys to support staff members to processing, investigating, and working on county legal issues and litigation. We handle all of the tort claim filings from inception. That includes the initial investigation, which is not required by statute for us to do, but we do it because of the contract. Policy drafting and review. Our DA opinion and advice does not include drafting contracts. It does not include drafting agenda items. It does not include drafting resolutions. It does not include drafting policies. We can give you advice on how to do that, but it does not include the actual work product of drafting. Attending board and committee meetings, that's not required to be done by statute. We do it because of the contract. That makes us accessible and available to you at the time you need the information, and so we are aware of what's going on in the meetings to help you. 228 meetings were attended last year by the DA's office. And we also assist with open records requests and giving advice and opinion on how to answer those. but that type of information is not required by the DA statutes. How a reduction in DA contract could impact legal services currently enjoyed by the county. This is a slide that I think is important for you to know, because if we broke it down to what our minimum statutory requirements were, the services would significantly reduce. One of the things in the statute, and I want to go back to that real quick. One of the things in the statute that's very important to notice is that we represent in only litigation cases, EOC representation, unemployment security representation, administrative court hearings, we would not represent. We only are required by statute to represent once the litigation is filed. Also, when it comes to giving opinion and advice, it says we give opinion and advice to the Board of County Commissioners collectively and to the other officers. It doesn't mean we give legal advice to individual commissioners on the individual status that they need. It's a collective from the BOCC. That's what the statute requires. And also, it doesn't require us to give legal advice to the HR, to the county manager, to individual, to benefits, to facilities management. Any request for legal services and advice would have to come from the Board of County Commissioners for the DA under the statute to answer it. So that's why I'm saying if you carve it back and you look at the reason why historically for years, for over 20 years, dating I think even before David Prater, we've had these contracts in place. It's because this county is the largest county in the state of Oklahoma, and a lot of DAs, there's only 3 that I know of, counties that offer a civil division, and that is Tulsa County, Oklahoma County, and Cleveland County and Norman. They are the largest ones, and they offer DA civil services. Every other DA across the state doesn't have a dedicated civil staff, doesn't have that, and a lot of the stuff that they do, they farm out to a company called Collins and Zorn, and they get their legal services from them. The DA doesn't even, they contract it away because they don't have the time or energy or resources to do it. That's why these contracts exist, and it is considered a cost benefit because they do pay for Collins and Zorn to do it. Each county is paying for legal services one way or another, whether we do it internally or not. But the majority of the counties are not just following the statutes, they are paying for legal services. So fiscal 2026 is going to present a lot of challenges. We've always discussed the 6 cases that are coming up and the legal challenges that are ahead of us. Adjusting the legal services contract backwards and taking away resources of the DA who is representing you in these litigation matters, it would put a strain on our ability to continue to perform at the level that we have been performing. And hopefully with new, as you all know, I just took over this position in December of 2025. So, we're trying to build a good cohesive team that is very responsive to your needs, that we can get this information and your needs met in a quick manner. It would jeopardize anything that we're trying to build going in the future, going into a very litigious year in which a lot of time and energy are going to be spent. So with that being said, I'm not going to read the rest of the PowerPoint presentation. I just want to emphasize that when a country goes to war, they don't start out by cutting back military funding for their military bases. The DA is your guard dog. We are the ones that are out there protecting the county from the litigation and the threats that are to the taxpayers' money. And we just feel like this is probably one of the areas where the spending is justified based upon the services provided and based upon the needs that the county has. And we would simply ask to keep the contract flat this year.
Okay, and that was going to be my next question. Can you remind me of the dollar amount of the current contract, fiscal year 26?
It's $699,42016. So $699,420 $420.16. Don't forget the 16 cents there.
And so you said you are offering a flat agreement for
Right.
fiscal year 27. So that will remain the same dollar amount.
Right.
Okay.
And on this last slide in 2024, this just goes to show you we did 852 requests for legal services compared to last year, which was 648. You know, it has gone down, but it's come back up.
Mhm.
And I think the reason it has come back up is because we have so many more things in the active litigation now and more questions that are happening now that I don't see that number trending down anytime soon. And that's the one thing that we're saying is like we're offering a flat contract, but I think the trend in 2026 is you're going to see, you know, requests for legal services that are going to be higher than that for this upcoming year.
Right. Right. Well, thank you so much for taking your time. Do we have questions, comments?
I'll make a comment on just presentation. Thank you very much for that. I know that took some time, and I appreciate you delineating the difference between what services you provide that are statutory and the extra services that you provide. So thank you for that.
Thank you. Thank you.
Any other comments? Okay. So this agenda item says discussion and possible action regarding the renewal of the contract for FY27 estimate of needs. And so would anybody like to make a recommendation to BOCC regarding this contract?
I'm not quite sure yet, to tell you the truth. I've been given direction as far as a District 3 vote. However, Ms. Bahena, Lisa, you all know the predicament that we're in as far as the strain financially on the county between the rent that we're paying over at Leadership and trying to find the best options for the DA's new home per se, whether it's ICB, whether it's something on the 4th floor, whatever. You also know that the ICB is a PBA building, and we have to pay back the bonds for PBA. And obviously, so we have to get some form of rent over there. And that's been the discussion this whole time. Where do we go from here?
Well, what I know is that when the district attorney's office agreed to move off the 5th floor so that it could be renewed and renovated for the court clerk's office, it was made well aware of the commissioners at that point in time that the 5th floor was way too small for the DA's office. The DA's office is not getting any smaller. At that time, I had 52 lawyers. I now have 67 lawyers in the DA's office. The reason I have an expanded staff is because my staff is operating on general felonies with a caseload of 340 cases apiece. That is a danger to public safety. And so I will continue to put the people in the seats that we need in order to keep Oklahoma County safe. That fact was, everybody was well aware of that the expansion that the DA's office in Oklahoma County is going through when the ICB building was promised to the DA's office, because there was an understanding that the DA's office was not getting any smaller. It is going to grow. I don't know what the plans are, and I'm not trying to appear ungrateful. I understand. But understand, too, that I get appropriations for the state for this much staff. This is all the money I get, and I have to spread that as thin as I can. I have carved out of our appropriations a payment of rent for the warehouse, don't forget that we're paying for, that was not making any money at $11,000 a month. That is at the risk of not having enough lawyers in seats to handle over the 11,000 cases that we file each year. I would say, if you're thinking about using the DA's office as a plan to reduce the budget, and I understand people are gonna have to be cut. This year, with this litigation that's pending and the number of requests that are coming into the civil division, I just fear that the county electeds, and particular the county commissioners, are not gonna get the service that they have become accustomed to by cutting this budget this year, with 6 serious 1983 cases pending. Are there any other questions?
I don't have any questions for the DA's office. I do believe that this item needs to be deferred. I do have some additional questions, not to the DA's office, but to county staff. And so I would like this item to be deferred.
Is that your motion?
That is my motion for this item to be deferred for 2 weeks.
Okay, so you want to have a special policy and governance
Yes,
reconvened before our next regularly scheduled meeting?
yes.
And
Okay.
we'll also need a special called where we could reconvene the item for Creoks. And so we can discuss that one as well at that time.
Okay, so we have a motion to defer for 2 weeks.
Yeah, I don't have an issue with deferring that, as long as we're dedicated in the next 2 weeks to discussing this musical chairs issue and everything that we have going on in the county.
But I want to be very clear. I do not support funds going to the Oklahoma County Jail. I just want to be very clear on that.
Okay, so the discussion on this agenda item is the agreement between the BOCC and the District Attorney's Office. And so the motion was to defer this item for 2 weeks. And was there a second? Any other discussion? All those in favor say aye.
Aye.
Aye. Thank you so much for your time.
They'll also need
The
to-
presentation, like Paul said, just really helps break it down and illustrate, the use of your time as far as we're concerned. So thank you.
I'll make a comment too, that I have no doubt as to the value that you provide the county with your services.
Okay, I think it is also my understanding that we have the District Attorney's Office available to speak on agenda item number 14. So without objection, I'd like to go to agenda item number 14, discussion and possible action regarding court services pretrial services program, GPS monitoring, and court service pretrial service contracts.
Okay, and so before we have DA Behenna come up and speak, I'll just give you an overview. So this is to look over the 3 contracts that comprise our pretrial services, which include the DA's MOU, which for FY27, all of these have remained flat at $61,246.92. That is for 1 employee and salary, benefits, and a cell phone stipend. So no change on that contract. The next is for the detention center's MOU, which is for $114,675.45. We year over year reduced that amount down from 3 employees, $145,000 roughly, to $114,000 for 2 employees at the detention center. And so that remains flat as well for FY27. And then the final contract, which is for TEAM for their pretrial services, that is remaining flat at $1,320,814.66. That does leave a deficit in regards to what we have available, since this was funded with one-time funding over the past 2 years. At Budget Board, we decided to use one-time general government funds to make up the difference of the $230,025. This year, we will have that same shortage.
You said 230,000.
Yeah, $230,025. But for FY27, because the previous contract was only for 11 months, for the DA, our shortage that we will need to ask for in my estimate of need or before BET and the Budget Board is $235,834.03.
And 3.
Yeah.
Okay.
So that is where we're at and what we'll need to ask for, and then I'll invite DA Behanna up to make any comments if she'd like.
So,
Eh,
sorry, go ahead.
And before you sit down, Jessica, is it any way that we can deal with these contracts separately, or do we have to vote on these individual?
So I did speak with DA Behanna whenever we worked through the past 2 years in regards to what this looks like, in regards to eliminating our court services department and what services are needed in order to continue to function as a pretrial service program. We did have a discussion in regards to whether the detention center was going to handle our pulling of, having an OLET, because they have an OLET terminal, pulling our NCICs and other reports needed, or if DA Behanna would have 3 staff, or at that time 4 staff in our office. And so at that time, last year or 2 years ago, we had determined that the detention center was going to handle that. But I visited with Ms. Behanna about it, and so she may have alternate options. But the program as a whole is functioning with these three contracts.
So I don't know that I need to go into the history of, and I'm happy to do that if there are questions about the pretrial services moving from court services and in-house department, for lack of a better word, to team. But I will tell you that the push to have a vibrant and robust pretrial services division and have team provide that service resulted from an opinion that Judge Friot issued, I believe, 2 years ago in Tulsa County. So there were some plaintiffs in Tulsa County that filed a declaratory judgment action against the county for failure to have a robust pretrial service program. In other words, they weren't having an individualized determination about whether or not this person should get bond and whether this person should stay in. Judge Friot issued a 120-page opinion. I thought I had put it in my pile to bring over. I did not. I am happy to email it to each of the commissioners so that you can read the statutory and constitutional responsibilities the criminal justice system has to ensure that somebody gets a bond hearing within 48 hours after their arrest, okay? So we had court services that was doing what I think is a minimal amount of service. We built up team to provide more of a robust service. For instance, we weren't pulling NCIC checks that were reviewed by the DA's office, the PD's office, and the court. We now do that. So right now what's happening is the jail will pull somebody's NCIC. And let me back up and just add this so that you'll understand why that's important. There are 2 reasons we can keep somebody in pretrial detention. One is they are a flight risk, they're failed to appear. And 2, they're a danger to society. And guns, drugs, a homicide case. And so without pulling an NCIC report, just looking at the charge, it's hard to make an informed decision of whether or not somebody is a danger. We might be able to see if they've been a failure to appear before, but we don't know their history. That's being done now, and that information is shared collectively with everybody that's involved in making a determination of whether or not this person should get bond or not. In addition to that, team has started, and I wish I could remember the acronym, but it's an assessment tool. They go in and they interview. Vicki Behanna gets arrested. I get interviews. Somebody's pulling my NCIC while team members are doing an interview of me to figure out, do I have a substance abuse problem, drugs or alcohol? Do I have mental illness? Do I have a stable home? Do I have family here? And based upon those answers, they give an assessment of what conditions should be placed on that person. So what Judge Friot said in his order is that it's a violation of due process and equal protection if people who do not have the ability to put a bond, to get a bondsman to give them a bond, have to stay in prison or pretrial detention because they don't have the money to have a bondsman. And so that's why it is necessary, absolutely necessary. And statutes provide for the counties to have a pretrial release program. That's what we started about 18, maybe 2 years ago now, and that's what we've been working under. And I have to tell you, it's worked beautifully. It's not cheap. It's not cheap. But we have to, as a county, if we're going to have a pretrial release program and not have the county do it, we've got to have these tools. We have to pull NCIC. We have to know who the person is that we're making a decision on. That information has to be disseminated to the courts, the DA, and the PD's office.
Now, my question relates to the turnover rate at the county jail for the staff. And it was brought to my attention by the PD's office that at one point in time recently, there was a backlog in the pulling of the NCICs because of turnover in staff at the county jail, which prevented people to get through the process faster because they didn't have at the county jail people to pull those NCICs. And so that's the reason why I asked the question as relates to jail staff being able to pull these NCICs. Would it be faster for the district attorney's office to add staff at the county jail to pull those NCICs, so we can get people in and out of the county jail faster than having jail employees to pull those NCICs, because we got to get people in and out of the county jail faster. I am not confident. And I'll say this publicly, I am not confident that jail staff can do it. I'm not confident because too many people are in and out of, too many staff people come and go at the county jail.
So, Mr. Pettis, I will look to make sure that we are getting that information relatively quickly. The constitutional standard is 48 hours. Okay, 48 hours you have to have a bond hearing. Somebody's got to be in court, even if it's virtual, but have a hearing to determine their eligibility for bond. It's my understanding we did have problems in the fall, in the latter part of last year. It's my understanding we are not having those problems. But I will say this. Initially, when we moved pretrial release from court services to team, the DA's office volunteered to be able to pull the NCIC so that we could get it quicker. I mean, I have an OLEDS terminal in my office. I probably, if the DA's office is tasked with pulling NCICs, and let me back up for a second. There are about 80 people that are arrested and booked in every day. Over the weekend, it's probably double that. So originally, I was volunteering the DA's office because we had the OLEDS terminal to go ahead and pull those NCICs. And I think at that time, the commissioners didn't want to give the DA's office money to do that. That's why it went to the jail. So if the county commissioners make a determination that they want the DA's office to pull NCICs, I think I gave some information to Jessica. We probably need another dedicated OLEDS terminal because we're also using OLEDS terminal to find witnesses that need to be found, defendants that have failed to appear, so that we've got an investigative unit that can go out and pick people up that need to be get a ride to the courthouse. And so there might be an additional expense of needing an OLEDS terminal and adding maybe one other staff member, but we can certainly do that and disseminate the information just like the jail was doing, if that's the decision that's made. I mean, I've already talked to my staff about the possibility of doing that, and they're well aware that they might be called to task to do that. So it's whatever you just, you have.
So would you need 2 employees and a new terminal, or just one additional? One employee?
One employee and one terminal.
So 1 terminal, 1 employee. Do we have any idea of what that terminal would cost?
Can I get that?
Sure,
I
sure.
think it's $1,000 to have the license but I don't want to speak out of turn.
Sure.
If I say that, that will be the wrong number. So if I can get back to you with the number on the
Yeah.
terminal.
Yeah, that'd be great. And I'd also want to ask a question that regarding that too. So say hypothetically you were to add a staff member dedicated to pulling these OLEDs and you did have an extra terminal. Would that be in lieu of the two people in detention doing those same things, or would that be in addition to the 2 staff members that are doing it in the detention center?
Replacement.
Okay, so basically as it is now, we have 2 people in the detention center pulling those in NCICs. You say that you can bring it in-house with the proper equipment with 1 staff member.
Well, I already have 2 people that pull in
Right,
CICs
but-
right
oh.
now.
But additionally,
Right.
okay,
One additional.
okay,
We would add one additional person to her, we would add one additional person to her current contract and then also pay for the services for the terminal and an additional terminal if needed. And so we can revise what that contract amount would be. Might be probably less than what we're currently paying,
mhm,
or maybe about, I don't know. So that's for
I think
2
it'd be
less. So I would just need to revise the contract in order to eliminate the detention center MOU and then add her additional expenses.
Well, thank you for being willing to kind of exercise that hypothetical. I mean, it sounds to me that if we could perhaps increase reaction time on these, as well as incur at least somewhat of a cost savings, it'd definitely be worth researching to see exactly what that would look like.
No, I'm happy to do that, and I will get back to you, Mr. Pettis, if that's okay, on whether or not there is a lag right now. Like I said, my last information was that we were getting NCICs. Somebody gets booked in on Thursday night, and we're getting NCICs Friday morning, but I have not verified that, so I'll check on that again. I can get back to you. I mean, this is an important service. It needs to be done correctly.
Mhm.
Not only does team do this assessment and help us determine what conditions need to be placed on somebody. Because somebody sometimes can get out on bond, but they need drug testing. Or we need to make sure that they get job placement, right? There's stability. If somebody is in a job and they're working and they're supporting their family, they're more likely to attend court, they're more likely to get their case resolved. So team provides the services on the front end to determine, does this person get out or not, and what conditions should we set? But they also do the supervision piece that we need. Some people need more touch than others. You all know that I came from the federal system, and the pretrial release program there is very robust. Again, they have a lot more financial resources than the county does, but team is pretty much equal to what I saw in the federal system and the services that they provide to people. Drug testing, counseling, mental health assessment. So all of that has to work together to really have a robust program. And I feel like after 2 years, we've kind of worked through the glitches and we're finally getting there, in my opinion.
So eliminating the contract with the detention center, pulling those NCICs and giving that contract to you, I think will save time and save resources.
Well, I'm very interested to see what that research brings. Perhaps we can, perhaps we can include this as an agenda item on our special that we'll call here in a couple of weeks.
Thank you.
Thank you.
Any other discussion on this agenda item?
I don't have a problem doing that at all. I am going to make another recommendation.
Okay.
I'll tell you that it is District 3 stance that court services should be brought back in-house. However, I will say that I don't see any way possible that would be planned, implemented, and funded by June 30th
Right.
for another year. So if it is the eventual desire of this board for the recommendation and BOCC to continue these contracts, my recommendation would be not only to do as you said, John, in terms of getting rid of the detention MOU, increasing the amount contracts for the DA's MOU, but also when it comes to team, if we were going to do this, I would say take their $1,184,903 that they were funded in 2025 in FY25, add 3% CPI each year for the 2 years. And that would, it doesn't save a tremendous amount, but that would bring team's contract to 1.257,063.59.
Okay, and so what savings does that realize? Do you have that calculated by
I
chance?
figured it out right here.
And then also, while you're calculating that, I as far as what team has taken on, just that aspect of it,
So
compared to what court services was doing, let's just talk about staff. So how many staff members does team have?
team has 15 staff members.
Okay, and then court services, when we had it in-house, had how many?
14, 15 staff members. It
14?
ranged anywhere from 14 to 15. The last year for FY24, which I compared our court services department's
Mhm.
estimated needs and their year-to-date, what was given to them in the end once we
Mhm.
went through, September supplemental and what their final budget was.
Right.
They had 1.1 million in salaries and benefits, and what team is currently operating off of, or what is requested for FY26, is $805,154. But they are also budgeting for a lot of different expenses compared to what I could find without really having a full understanding of that department and how it functioned, because it was eliminated, I think, my first year that I was here. They have a lot of more expense that goes towards Salesforce, their drug testing, their a lot of expense that goes towards ankle monitoring. They do not charge for ankle monitoring, and we were bringing in a lot of revenue in-house.
Right.
And then, of course, their incentives, bus passes, I didn't see that budgeted for, from what I could tell, for court services. And so really two kind of different operations. But if you're going to decrease their budget by, roughly $100,000, definitely is what it looks like you're anticipating roughly.
It's
What
looking
was the
like
number?
just the team portion, savings of
So-
63,751.07.
Okay.
But
'cause-
that combined with, if we took the
Some cost
suggestion of the
savings of
DAs
moving,
doing
then
the
it
NCICs, we could
perhaps
be up
would
to
be a
100,000.
wash.
We could be
Yeah.
up to 100,000 savings between the two.
Yeah, but
Okay.
a total of
And
100,000.
right now, every little bit counts.
Absolutely.
Well,
And I'm sorry, Jessica.
So, and then I guess my next question for me personally, since this is my estimate of need for general government, are you looking for me to try to find whatever is remaining? Maybe if we could take off 100,000, that 135,000 that's still remaining. Would you like for me to try to find that within my general government budget? The only thing that I can think of that we budget in excess of is outside legal. We usually budget around 700,000. The contracts year over year have only been around 200,000, and I know we have legal services that may come up, but it's really the only thing that is extra that I have, or we can vet it out in BET.
I think for me personally, I think the first piece of information would be to see if there's a cost savings realized with moving away from two detention people pulling NCICs to the DA's office, and see exactly what cost savings, if any, that would realize, and then kind of apply that, go forward to the thought process with the remaining.
Sure. And I can also have, a conversation with Chris Steele at team to see if there's anything, because they were able to last year over this year decrease by 20,000 and see if there's anything that we could possibly do for this year.
Well, and I do also want to mention, I think I would be remiss if I didn't say that we certainly realize that with the program being where it is now, like Ms. Behenna said, is much more robust as far as the services provided and the things encompassing in that, compared to what it was prior. And so I think even with that aspect alone might make it a little difficult to compare truly apples to apples. But that's really why I wanted to look at even the number of staff members. They operate with 15. I know Court Services for at least part of the time operated with 14. And so teams got at least one more staff member, in addition to a lot of other things that they are providing. So I just wanted to mention that.
I'd also like to note that with the DA's contract currently, the employee that is billing for the GPS monitoring that they're providing within their office is doing an excellent job. So far, year to date, or month to date, year to date, she has brought in $44,745.24. And so that is paying for the GPS monitoring that they are currently doing with excess. Currently, my GPS expense
So that's able
is
to
at
sustain
$26,000.
itself. That's great. Okay, do we have any more discussion on this item? Okay, do we have a motion to defer?
I'll motion to defer it for, we're gonna bring it up in the same as the other one, 2
2
weeks.
weeks.
2 weeks.
Okay. We have a motion.
And a second?
All those in favor?
Aye.
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 Okay, great. Thank you so much. Thank you, Ms. Behenna. So now we will go ahead and move up to the top of the agenda and go back through in order, starting with agenda item number 2, discussion and possible action regarding GPS monitoring for the indigent.
Hello. So this item was deferred from the last policy and governance meeting. Whenever we did our estimate of need, or we were working through the process of the second year of contracting again in regards to for these services, there is 3 funds. There is the Court Services General Government Fund, and this never changed from the time that we set up and we're operating this in-house, and we've just kept these contracts within that 301 fund. So there's a General Government 301 fund, and then that is where the contracts are held. And there's also 2 special revenue funds. There's a 1260 301 and a 1260 302. Currently, the way that I'm handling it, this is out of 301 is where I'm depositing or appropriating the funds, those GPS revenue funds that I was talking about. That's where those are going, and then I'm paying Allied Universal for those services, and that is also where I will pay for Kathy Taylor or the employee's cell phone. The 302 fund, on the other hand, is a fund that has been continued to receive funding if needed for any type of GPS monitoring for the indigent. And so that fund carried over roughly $50,000, and then there was also $6,000 in carryover. So the total balance that it has is $56,694.77. I have, to this date, have not received any invoices or any direction from this committee in regards to if we're going to continue to provide indigent GPS monitoring. I then requested a DA opinion, which was provided at the last policy and governance meeting, and then we ended up deferring it because I needed to have a little bit further discussion with DA Behenna in regards to are these services the same services or similar services than what Team's already offering? Because currently they're not charging for GPS, and as you can see, they're budgeting for over $70,000 in order to support it. And she's here today to talk about those differences. But since then, I have got an email in regards to that we have 3 people currently on GPS monitoring that would qualify for the use of these funds as we have handled them historically. And so I've got 3 that are currently using, that they're currently using Allied Universal for, and then we have 1 lost GPS unit. And so eventually I will have an amount that I will need to pay, and historically we've paid out of the 302. And so, and I do not know what that will cost as of right now, but eventually I'm going to receive an invoice for that, and I just need permission in order, or direction, if we're going to continue to handle that fund the way that we've handled it in the past.
Okay, perhaps I don't understand really all the logistics of how it works, but if Team is already funding a certain amount to pay for GPS monitoring. Could these 3 people utilize that service with team under what they are already budgeting for?
This was an issue that was raised when we first started to do shift from court services to team. And the quick answer is no, and here's the reason why. The monitoring that Kathy does in the DA's office are for defendants who are high value and high risk defendants. Some of those defendants are assisting and cooperating with law enforcement, hence the need for a GPS monitor. If they're going to be doing buys, we need to know where they are and where they were before they came to the buy. I think at that point in time, when I was explaining this to commissioners, they thought, well, let's let team do that. I don't think law enforcement felt entirely comfortable with having, because a co-defendant might be at team, and then there might be another co-defendant that has least restrictions, but is on a GPS monitoring. Questions can get asked. And so a decision was made at that point in time to have these higher value defendants. I know that sounds kind of silly, but to carve out this exception for those individuals who were trying to work off and help law enforcement.
Okay, so there are extenuating circumstances that fall outside of the scope of what team can provide. Okay.
And I think right now you should know that for the most part, that's why Kathy has been very successful in getting over $40,000 from people that are on monitoring by Kathy. But some individuals, the court will say, I want Kathy to do your GPS monitoring. And they don't have the money to pay for it. That's the need for an indigent fund. It's not that we say, hey, look, Kathy will monitor you and we'll pay for it, or the county will pay for it. That's usually by court order.
Okay. And so is there a law against, or is it not acceptable to roll the 302 into the 301? And then just pay all the fees out of that, whether they be indigent or what Kathleen Taylor presently does, and just have it all together in one.
That would be my preference,
Okay.
just because that's where the other PO is
Right.
held. And so what I would have to do is I would have to transfer that full $56,000 over to 301 in order to even use it. And
Okay. So
that
you
was
would
going
want
to
to
be
do
my
that
next
anyway.
recommendation,
And
is that
so-
I was going to transfer it.
Okay. And so there's no restrictions as far as commingling that, rolling the 302 into the 301. Okay.
No, they've just had kept it separate in the past. I will still have 2 separate POs with Allied Universal,
sure.
so that way I can track the 2 expenses
Yes.
separately.
Within
But I
the
don't
same.
see a need. Maybe there was a need before, or maybe we do keep 302. There's multiple ways of doing it. Keep 302, so that way you have a specific fund for
Well, it
GPS
seems like it
monitoring.
would
Lisa, I
be-
think in your opinion, we may have had to have a program established for indigent GPS monitoring, and if that is the case, then that may be the reason why we justify having that fund rather than commingling it with the other.
I think if
special revenue.
you can identify it with different purchase orders within that fund, personally, if with no objection, I would think that would be sufficient.
The actual pretrial, like the whole pretrial detention program, once it is created, which it already has been, GPS monitoring is already part of that by statute.
Right.
So, whatever funding you have for that program can be utilized for GPS monitoring, whether it's indigent or not. The determination of whether or not somebody pays for that is by court order. So that's really not in the control of the BOCC. So obviously if somebody, and the court doesn't have to declare indigency as a reason, they can just say, you're going to pay, you're not going to pay. And I usually think the courts do take into consideration that somebody can't, but we can't. The one thing that you got to watch, and that's what the opinion was talking about, is you can't really base whether or not somebody qualifies for an ankle monitor on the basis of whether or not they can pay or not. That would be a terrible policy decision from a constitutional standpoint. So like I said, when I talk about the indigent part of this, to me, it's just GPS monitoring. There's not really a distinction to me of whether or not we're paying for indigent or not, because the program itself encompasses payment for that.
Okay,
Yeah.
perfect. Okay.
Originally, my thought last year is that since these are professional services contracts, that we would just put it under general government, and then we also have and then we have the special revenue fund for any, funds that are coming in. But since there is, possible interest at some year, in the future that could be brought in-house, keeping a 301 general government for pretrial or court services, and then just having one special revenue fund, that once those funds specifically that we've budgeted for in that fund run out, then I'd have to go and ask that line item.
Mhm.
I'd have to go, ask BET for
Just for it
additional
to be
funds.
replenished.
Yeah, rather than it being, its own separate revenue
Right,
fund.
right.
And so
Okay.
that would just be my preference, but that's, I just mainly needed to know that I do have the permission in order to move forward with paying for those out of those dollars, so that way I can transfer them to where I have access.
Okay, and so then you're talking about just taking the $56,694.77 from 302 and just rolling it into 301, and then utilizing a separate PO for indigent. Okay.
Especially if that's the interest, and we can talk about it further in BET.
I'm
if we're gonna
satisfied
eliminate
with
it.
that.
Okay.
Are you guys satisfied with that? Okay, that'll be my motion.
Thank you.
Oh, yes, I will restate that. My motion is to take the $56,694.77 that is currently sitting in the 302 indigent fund, and then just roll that into the 301 where she deposits the GPS revenues to pay Allied Universal, and then utilize that with a separate PO for indigent
Yeah, court order.
as needed. Yes. Okay, I had a motion
Yep, I second it.
and a second. All those in favor? Aye. Okay. Thank you, Jessica. Thank you, Ms. Behenna. Thank you, Lisa. I see that we are past time for the BET meeting next door, and so I will entertain a motion to recess this meeting until perhaps sometime this afternoon. Are there any constraints this afternoon, Sharon? Okay. I might suggest possibly 1:30, maybe 2.
I have a meeting until 2.
So 2 o'clock?
Yeah, usually.
Okay, so
2 p.m.
I will make a motion to recess until 2 p.m.
Second.
All right, all those in favor?
Aye.
Aye. Thank you, everybody.